Hello, welcome to our annual estate planning workshop. I'm Sally Baker, Senior Director of Plan Giving at the University of Michigan. A couple housekeeping items before we begin. Our panelists will answer questions during the last portion of the webinar. Questions can be asked using the Q&A feature at the bottom of your screen, and it can be typed into the Q&A window anytime during the webinar. Live captioning is also available during today's program. To view captions, please click on Closed Caption at the bottom right of your screen and choose Show Subtitle. I'm pleased to introduce our panelists. Marie Daveny is a member at the Dykema Law Firm. She leads a team of 4 estate planning attorneys in the Ann Arbor office. Her practice focuses on gift, estate, and generation skipping transfer tax planning, probate and trust administration, wills and trust agreements, and retirement distribution planning. She's a member of the Distinguished American Council of Trust and Estate Counsel and has been recognized repeatedly in Chamber's High Net Worth Guide and is one of the best lawyers in America and Michigan's super lawyers. Prior to practicing law, Marie was on the faculty at the University of Michigan Law School. And before that, she clerked at the United States Supreme Court for the legendary Justice William J. Brennan, Jr. Before going to law school at U of M, Marie was a curator of the slide and photograph collection at U of M's Art History Department. She also has a master's degree in art history from U of M. Doug Kelly is a tax principal located in Raymond's Ann Arbor office. He has served as the lead engagement professional on multiple compliance and consulting engagements involving multi-tier partnership, LLC flow-through structures, and has been responsible for annual tax compliance of clients in real estate, high net worth individuals, exempt organizations, and a publicly traded real estate investment trust. Doug works extensively with individuals as well as local area financial institutions regarding their individual tax, income tax, and fiduciary tax reporting requirements, and the implementation of planning ideas, including charitable giving, succession, and estate planning. Doug graduated from Eastern Michigan University with a BBA in accounting, at which time he joined Deloitte Tax. He has nearly 20 years of experience with Deloitte, providing tax consulting and compliance services. For several of those years, he served in the National Research and Development Group, focusing on specialized credits and incentives. Doug joined Raymond in 2013 to continue to work with many of the same clients he had built relationships with over the years. Donna Snyder joined the University of Michigan's Office of Vice President and General Counsel in 1997 and is Associate General Counsel. Her practice focuses on charitable giving to the university. She assists fundraising professionals and others in the university with legal, tax, policy, and due diligence issues of giving charitable gifts to the university, and she drafts agreements for major gifts. She works with current and planned gifts, including gifts of various assets, particularly those that are difficult to value or have unusual characteristics. She assists in all aspects of making gifts acceptable to the university, including negotiating gift agreements with donors' attorneys, assisting in the university's adopting policies and regarding charitable gifts, and other matters relating to donating to the university. Prior to joining the university, she was trust counsel at Fifth Third Bank in Cincinnati, Ohio, where she advised trust personnel on fiduciary law issues, including matters relating to trusts, estates, investments, and charitable planning. Donna received her law degree from the College of William and Mary in Williamsburg, Virginia, and her bachelor's degree from the University of Akron in Akron, Ohio. Now, without further ado, I give you our panelists.
Thank you very much, Sally. We're very glad today to have Marie Daveny and Doug Kelly to talk to. I'm going to be mostly asking the questions. Marie and Doug will be answering them. And we're going to have basically 3 sections. So the first part will be in general drafting, initiating estate planning. Second part on federal tax law changes, including the question that's already popped up in the question place. And the third part on charitable gift planning. So let's start off. There's been, during COVID-19 pandemic, a lot of people have seemed to think about their estate planning. Marie, would you mind giving us a brief overview of how property passes at death?
Yeah, happy to. And you're exactly right. I've noticed a real, increase starting in March of clients coming back for updates, finishing up estate plans that they had started but never gotten around to finishing. But as to how property passes at death, I try to combat with clients what I think of as the mystique of the will, that people think that the will, I've got a will, my will does everything. Well, I explain to people that we work with really what you might think of as 4 transportation systems plus statutory transportation systems in designing an estate plan to transfer a client's property at death to the people they want to give it. And so those transportation systems are joint property. If you own something jointly with someone with rights of survivorship, the survivor owns it automatically by operation of law. Beneficiary designation is incredibly important, and we'll be talking about that a lot today. Classically, it's used for life insurance and retirement accounts, so that moves the property. If someone has a revocable trust that becomes irrevocable at their death and puts assets in it during their lifetime, we use that as a tool to move property at death. And then if there's something left over, an asset that didn't get moved by one of those other transportation systems, the will picks it up and moves it along. And if you're working with a trust, it generally is told, pick it up and put it in my trust. Now, sometimes though, we need to rely on statutory systems for transferring property at death. And that would be in simple situations, we use it for transferring ordinary cars. But if someone dies without a will, the property that would have been moved by will, had they had a will, is moved instead by what's called the law of intestacy, dying without a will. And the results of that can be surprising to some folks. So it's important not to rely on it. I can just very briefly remember one situation where a man died, leaving a wife and his mother. And the wife assumed that she would get 100%. And actually the law of intestacy left the first X dollars to her, 50% to the wife of the remainder, and 50% to the mother. Now, the mother was cooperative and we got it all to the wife, but you don't want to let a statute decide your estate plan.
Thank you. And while we're talking about that, so what kind of documents do people really need to think about during their planning?
So basic estate plan. The basic estate plan involves a will, at least, generally a will and a trust, and then powers of attorney for dealing with the possibility that you might benefit from somebody helping to manage your financial affairs and medical decisions for you if you have a period of incapacity. And also always important beneficiary designations for retirement accounts and life insurance. Those are the basics.
Okay.
More advanced estate planning, irrevocable trusts, other techniques.
Okay. And also probably the medical powers of attorney.
Yeah, that was in the power of, yeah, exactly.
Right. Yeah, exactly. So what kind of factors do people consider when they're deciding whether to do a trust or just a will?
Well, I have to say I favor using trusts and wills together because at the very least you can minimize or avoid the need to use a will, so you can simplify administration after your death if you have a trust and fund it during your lifetime. And it also is a good tool for managing assets for you if you as you age and maybe need some help managing your financial affairs. And then in addition, trusts are used to manage, they're designed very specifically for the client's objectives, but things like managing property for the benefit of a young person, the benefit of an individual who has difficulty managing assets or shouldn't be managing them because they're trying to preserve eligibility for need-based benefits. So many reasons to discuss with your attorney.
Very good. When should folks include family in their estate planning?
Yeah, so I think there are 2 categories of family, two types of family that you'd want to consult in different situations. One is if you're naming family members as fiduciaries, meaning to do things for you, like guardians for your children, trustees for your children, holding special powers. You really want to talk to them in advance and make sure that they're comfortable with it, understand the role that they're being asked to play. That one's pretty obvious. But the one that I think is more interesting and should be done often is involving adult beneficiaries, usually adult children. in the estate plan, if a client's willing to do that. And I see two categories of topics and two reasons. One is to structure the estate plan in a way that's good for your kids and that they think would be helpful to them. So if you involve your adult children in deciding whether they're going to receive their inheritance outright or in a trust, you can talk to them about whether a trust would be helpful for them, because we can do it for tax planning for them, actually estate planning for them. Also, it can provide asset protection for them. So if there are difficulties in a marriage, or if somebody has a business and is always being asked to guarantee loans for their business, we can safeguard these assets in the trust, set them aside. So, and I find that adult children respond very well to that inquiry and the opportunity to give some input about what's going to work for them and for their families. So that's one context. The other one is what I call the no surprises rule. You really don't want surprises when people die. And so if the plan is anything other than what children, and this is the most common situation involving children, if it's anything other than what they would ordinarily expect, which would be 100% of the assets to the kids, or nearly 100%, equally divided, no distinction. If it's anything other than that, let people know and let them know how it's going to go. If you have a child with special needs and you're going to devote more resources to that person because they're going to need them more than your other kids who are fully capable, have the conversation, tell the kids what you're doing and why. And your attorney would be, I would believe, happy to have that kind of family meeting. I've had many of them myself. And again, they work really well, and you manage expectations that way.
Thank you very much. I totally agree with that. From the university's point of view, we certainly have had some family members be surprised and had some unfortunate litigation result from it. So it really helps. I really appreciate your saying that. You mentioned that one of the categories, if you will, of family is when they are personal representatives. So how does somebody think about having, deciding whether to have family members for personal representatives or a corporate trustee or whatever?
Yeah, sure. So for deciding who's going to settle your estate and manage your affairs during your incapacity, what I tell clients is if you have a suitable family member or friend who has the time to do it, that can be a fine solution. The qualities you look for in a trustee or a personal representative are the ability to get tasks done, take instruction well, work with a team consisting of the estate attorney and the CPA usually, and usually the financial advisor, form a really good team to help execute. But if you know that your family members are really nice people, the best people, but just can't get anything done, that is really a bad choice. I've seen it. We go chasing them, and it costs more for us to chase them to get things done than if you had somebody who's going to get them done the first time they're told what they need to do. Where a corporate trustee makes a lot of sense, corporate fiduciary, would be situations where you really don't have family members or friends who would be appropriate. That's number one. But also where there's any acrimony in the family, among family members, suspicion of family members. I've had situations where, the oldest child was named the fiduciary, and the oldest child had very bad financial circumstances, and everybody else was worried they were going to be siphoning off the money. I mean, those are the kinds of things where you can avoid these problems with a corporate fiduciary. Blended families, second marriages, all of those are situations where with a corporate fiduciary, you're putting someone who's neutral, third party, who's going to be transparent, disclosure to everyone, just brings the temperature in the room down.
Yeah. Doug, you've heard this too. Would you like to add anything to that? You're muted.
Let's try that again. Sorry, maybe not add anything new, but just reiterate the importance of the communication amongst the family members, especially in this regard. I think Marie and I both have plenty of examples of where the family dynamics have gone askew because of the situations on who was selected. Was a sibling put as a trustee of one of their siblings' trust, and then they're forced to potentially go to a situation where they're asking them for money or permission, and it adds a lot of challenges. The other part that I would really encourage is that the individuals spend time with who those fiduciary agents may be ahead of time and really express what their wishes are, which will be spelled out in the agreement, but also how they think. A lot of times, you know, when you're serving in that role and you're able to communicate a relationship that you had with the decedent, it adds comfort to the beneficiary that they know you, that they know the decedents, and they can work together to get to the right answer that the decedents may have wanted.
Right. Thank you. So how often, I'm going to flip back to Marie this time, how often would you say that folks should review their estate plan or update it? Is there a certain number of years or life events, or what are you thinking?
Yeah, both years and life events. So life events, if anything big changes, marriages, divorces, deaths, retirements, sale of a business, anything that changes your assets significantly. You read about big changes in the tax laws in the newspaper. All of those events are ones where you should call your attorney to review. But in addition to that, I recommend that clients revisit their estate plan. It depends on their age generally, but for older people, maybe every 2 years, and for younger people, every 5 years. Maybe very young people who are starting out can go a little longer. But what that gives us is a chance to address any changes in both in circumstances and changes in the law that may have occurred. We can get things up to date if you just check in on a somewhat regular basis.
Great. So let's change course now and talk about taxes. A favorite thing for everybody, right? Doug, would you give us some highlights of the Secure Act and CARES Act and changes that have happened that will affect folks?
Absolutely. And I actually think we probably need to start real quick with the Tax Cuts and Jobs Act, which was what was passed in late 2017. Us tax accountants talk about it as our Christmas present. Not really, because it was literally right before then, and we had the holidays of trying to scramble to learn the new rules. But it is really the rules that are currently driving the majority of the income tax situations that we're facing today. It is scheduled to revert back to the old law in January of 2026 without any other changes. So this is not a permanent law change, at least from an individual standpoint, which is what I'm going to focus on today. As most have probably heard, the tax rates, the tiered tax rate structures, on average dropped 1.5% to 3% in rate. There was an expansion of the tiered brackets. They removed the marriage tax penalty by duplicating the tiers of a single individual and a married filing joint individual. They added a significant deduction in a lot of cases called a qualified business income deduction, which was meant to try to equate to a similar tax rate for the corporate structure, which was moved to 21% to the individual flow through, which went from 39.6% down to 37%. You might ask, well, how is 21% and 37% even close to each other? Well, this qualified business income deduction essentially gave an additional 20% adjustment to that rate. So you get into the 29% rate, 29.5%, and that still seems significantly different, but the earnings within a corporate structure have to be passed out as dividends and get taxed a second time. And so when you get those pulled together, they kind of get much closer in rates. But what we're really talking about is some of the significant changes that occurred from a deduction standpoint. And that really then leads to the charitable aspects. Personal exemptions went away beginning in 2018.
Right.
the standard deduction doubled in size up to about $24,000 for a married filing joint instead of $12,000. Itemized deductions, there were significant limitations. State taxes, which include your income tax and your real estate taxes, got capped at $10,000. Miscellaneous deductions, which were subjected to a separate calculation, but often involved investment type activities, were deemed to be non-deductible under the new regime. And so what has happened is there is a significantly fewer number of individuals who are claiming the itemized deductions on a year-over-year basis because the standard deduction is more beneficial. So what that means from an income tax planning standpoint is you really need to focus on the charitable deductions, the charitable giving, to make sure that you're trying to maximize that in a particular year. You know, how do you do that? Well, first of all, they changed the rule and said that 60% of your adjusted gross income could be given to a public charity in a given year and be deductible. So you also look to larger accumulation of gifts at one time. We call it bucketing or pooling gifts. So maybe instead of doing the same amount each year, you do 2 or 3 years worth at one time so that you maximize the gift.
Yeah, I heard it called bunching too.
Bunching, yeah, exactly.
Together, right.
Yep. Utilization of the qualified charitable distribution for IRAs. That one is an extremely large one that may not have been as important in years past. And what that is it allows for a distribution from an IRA to be directed directly to a charitable organization as part of your required minimum distributions, or just your distributions if you've met the mandatory age for distributions. And instead of picking it up as income and getting a deduction on your return, it is reported as a non-event. So you don't pick up the taxable income and you don't get the deduction. But in a year when maybe you were not getting the deduction from an itemized standpoint, the fact that you don't have to pick up the income and you still get the standard deduction, that's a big difference. Let's move on to the CARES Act, and I'll come back to the Secure Act in just a second. The CARES Act is what was passed this last spring in 2020. It really was a legislation meant for economic stimulus and support, but It did have a couple of income tax ramifications from an individual standpoint. First of all, there are no required minimum distributions for 2020. For those individuals that might otherwise have to be, you do not have to take one for 2020, and it's not a catch-up provision. You don't have to take 2 of them in 2021. It is a year that'll just be passed. That doesn't mean that you can't still distribute from an IRA for a charitable purpose, but you would really want to make sure that you're doing that under the qualified charitable distribution rules. You know, for those who are non-itemizers, and this is really immaterial at the end of the day, but if you're not itemizing, there's a $300 deduction above the line. So it really wasn't the stimulus that I think individuals in Congress were hoping. There's many other deductions that come into play from a business standpoint related to immediate expensing, net operating loss carryovers, and everything else. And this goes much beyond the purview of this particular presentation. And all I can do is encourage you to reach out to your advisors and package that in with any other planning that you're looking at from an estate planning or from a contribution planning standpoint to make sure that you're maximizing those.
Well, that's actually a very good segue to my next question to Marie, which is what steps should individuals take to be sure their estate plans work with this intended tax law? And we'll get back to the Secure Act in a second, but or would you rather do that first?
I think I can talk probably about the Secure Act very quickly, at least the part that affects the estate planning.
Okay.
That was the act that became effective in January that made a major sort of earth-shaking change to how retirement accounts have to be distributed after the death of the owner. And the owner means the original owner, and if you leave it to your spouse can become the owner. So if we're dealing with a married couple, it's at the death of the survivor when it, again, typically would go to kids, or a lot of times we'd make trusts for grandchildren, the beneficiaries, because if structured properly, one could use the life expectancy of the beneficiary to measure the minimum required distributions after the death of the owner. So if you had a grandchild who was the beneficiary of your IRA, you might get a 60, or depending on the age of the grandchild, and we'd use a trust for this, you might get a 60 or 70-year payout. I mean, even with a child, you get many, many more years of tax deferred growth. And that was, I guess, just too good of a thing to leave alone. And the decision was made to accelerate the payout. So for most beneficiaries, not spouses, but for most beneficiaries now, the entire retirement account has to be distributed within 10 years after the death of the account owner. There are exceptions for minor children of the decedent, not grandchildren, but the decedent's minor children, beneficiaries who have disabilities or are chronically ill. You know, there are some exceptions, but that's the general rule. And because of that change, everyone who has retirement accounts should check their beneficiary designations, should check them with their attorney. And if trusts are involved, if you've named a trust the beneficiary, it's very important to talk to your attorney about whether, at the very least, a technical amendment to your trust is needed, just to reflect the changes in the law and the language in the document. But also, many of these trusts were drafted and made the beneficiary of retirement accounts on the understanding that it would be distributed to the beneficiary in very small increments over a very long period of time. And now we're looking at a force out within 10 years. And that might be a reason to reconsider that decision and that plan. So for some clients, there's going to be reconsideration. There's a lot of planning that can be done around this, though, because it does not have to, there's no requirement to take it in any particular installments. You don't have to take a 10th each year. You can wait until the end of the 10 years to take it all. But I'm telling clients I am very worried here that beneficiaries will forget about it, that they're going to just put it on cruise control, which people tend to do. If you miss that deadline, there is a 50% penalty tax on what you were supposed to take but didn't. So it's really serious business. And if you have trust, think about your fiduciaries. And this is where I'm thinking even more about corporate fiduciaries, because I know they're going to be keeping track of that deadline.
Right.
Yeah.
So Doug, do you have anything to add on the Secure Act?
Not on the Secure Act specifically.
Okay.
No.
But I do want you to, if you don't mind, opine on what you think retirement planning is like now after these tax changes. Is it still a good vehicle for charitable gifts as well?
I think they absolutely are still good vehicles. And actually, in a lot of cases, I would tell you, I think they're better vehicles than they were before. Because what was a significant part, as Maria talked about, of the idea of a cash flow that was spread out over time and reduced the income tax ramifications over the time period of a beneficiary, individual beneficiary being named, it might make a lot more sense for a charitable beneficiary to receive those IRA assets or a portion of those IRA assets. IRA accounts come pregnant with significant income tax ramifications. There's no basis in the asset and there's no basis step up at death. So it's all going to come out as income tax or subjected to income tax upon distribution. If you pass it along to a charity, income tax is completely avoided in that case. There were reasons before where it made more sense to let it spread out, but now maybe it makes sense to distribute other assets to family members or other beneficiaries who are going to receive assets with a step up in basis and maybe do something differently than an IRA account.
Okay. Do either of you have some advice on counseling on beneficiary designations and particularly the consequence of handling them correctly or incorrectly?
Yeah, if I could just chime in briefly, because I know we want to talk about the maybe pending tax changes. Just want to say beneficiary designations for retirement accounts, except in the simplest possible situation, are not a do-it-yourself project. You should definitely involve your attorney in the crafting of them at the very simplest level. Many forms do not have a provision for saying, if, you know, I've named my kids, and that's great, you can do that in equal shares, but what if a child predeceases you, leaving children? You want to be sure that that deceased child's share gets to their children and not redistributed instead over the other folks. But the other reason to check is very often we're doing planning with clients' beneficiary designations for retirement accounts, charitable planning, trust planning, and I'll give you an example of one that went wrong. And this is where the clients didn't check in. I say to clients, your beneficiary designations for your retirement accounts are as important an estate planning document as your will and your trust. And you wouldn't, most of my clients wouldn't dream of messing around with those, you know. And I had one client for whom we did a very careful estate plan. He had very specific desires for his family. He wanted trusts, education trusts for the children of his nieces and nephews. But he also had a favorite charity that he wanted to designate funds to. And we did that. That was the estate plan. Well, his financial advisor changed firms. And so they had to redo the beneficiary designations we had so carefully done. And my client and his advisor sat down and they said, "Now, what was the beneficiary? Oh, yeah, it's your trust. Yeah, right. We make it the trust." And my client went off on vacation and died. And we never got to get his favorite charity never got what he intended. So be careful there and involve your attorney.
Thank you. Okay, you sort of tipped the hand there, Marie, but Doug, what kind of tax law changes might you be on the horizon? And someone has actually asked if you anticipate a flurry of year-end activity of prospects.
It's already started.
It's already started. Yeah. And I've told a lot of my clients and friends that I feel like my crystal ball this year in 2020 has been used more like a basketball than anything else. So take that all with a grain of salt. But it is clear that based on what Joe Biden has said, that if he is elected, and there's many steps that need to be involved to put everything in the perfect alignment. From one perspective, if you call increased taxes perfect alignment, but you know, he's been very clear that his plan calls for increased income taxes associated with those individuals that are making more than $400,000 a year. A lot of it is a reversion to the old tax law that was in place prior to the Tax Cuts and Jobs Act of 2017. But there are some additional things, potentially removing the preferred capital gains rates on sale of stock or assets and on qualified dividends, changes in regards to the deductions again, all of those types of things. He has not been as clear in regards to what his thoughts are for estate planning, although it does seem to have a lot of guidance that it would again revert back to the old rule of a $5 million lifetime exemption that would be inflated for cost of living. But one of the things that I found interesting in that is that maybe there wouldn't be a step up in basis. So there's a lot of things that are coming into play. With that said, we need to look at this. We need to plan for things as they come up over the next couple of weeks and how the election comes out. But it involves Senate and how that ultimately is held, who is the president, what the timing is. And so I do think it's something that needs to be dealt with in a time appropriate manner, but it may not be a hard and fast 12/31 year end type situation like they did a couple of years ago back in 2012. I think it's still going to be a very busy time for Marie, in particular from a drafting standpoint, myself in talking with clients, but there's much more to come over the next several weeks to see how it happens.
Yeah, Donna, if I could just chime in. Yeah, I'm already seeing very significant interest, especially the concern is that the exemption from the estate/gift tax, their combined tax, and the generation skipping tax, that's going to be rolled back and that people will lose the very large exemptions they have. Right now, it's a maximum of $11,580,000 a person for each of the gift estate tax exemption and the separate generation skipping tax exemption. And clients who have the resources to do it are planning right now and are trying to use those exemptions. And they're doing that in a variety of ways, but very common ways. The things that I'm seeing the most of right now, and we're already doing a lot of it, is creating and funding trusts for a spouse. These are called spousal lifetime access trusts, where one spouse creates a trust for the other spouse and moves assets equal to their exemption amount into that trust. And at least, the spouse beneficiary is getting the income, and that keeps the income available in that marital unit, at least during the lifetime of that spouse, and then can go on down to the kids, protected from estate and generation skipping tax. And lots of trusts for children and grandchildren to take full advantage of these exemptions that we may not have in the future. And everybody's worried that if there is a change next year, it could be retroactive to the first of the year, whereas we feel safe if there's funding done this year.
Well, I think that actually answers one question that someone asked, and that's, even if Joe Biden does get elected and gets these changes through, it will take some time because of the legislature. But as you pointed out, it's possible that they could, that these changes could be passed and then they could become retroactive. So anyway, as both of you have said, we just have to keep an eye on everything. So let's move on to the charitable gift planning portion. Doug, let's start with you. What are the most common questions you are asked about charitable giving?
Well, it's an overall perspective. I mean, in a lot of cases, I'm talking with clients who are considering very significant gifts and maybe trying to set up a legacy. And so they start with, a family foundation. Does it make sense to form a family foundation and involve the next generation in doing that type of gifting? And often that discussion then turns back to maybe the more appropriate manner of what you're trying to do would be a donor advised fund. It's a much simpler structure. There's less corporate responsibility from annual reporting and documentation of minutes. They're often set up with organizations like the University of Michigan, where they're able to be structured already. And so that's one piece of it. Then it's, the obvious, how do we maximize the deductions? And we talked about that briefly beforehand with the bunching or pooling. And as we start to talk more about things, what are some of these larger structured gifts that we might be able to do? A charitable remainder trust, a charitable lead trust. What are some of the other options that might exist that allow us to start to see the benefit of the charitable intent while we're still here versus after we've passed?
Right. Good point.
Donna, can I say something there?
Absolutely.
Loop in Doug. This year, I think one thing that one change in the law is that I think it was the CARES Act, there's no limit on how much of your adjusted gross income can be deducted for charitable purposes. And I've got clients who are doing planning with that. They figure that at this point, they can make very large gifts this year to charity. Some are choosing to endow their annual giving. They're creating endowment funds to generate, so that once they die, their principal charities will get a stream of income that's a functional replacement of the annual gifts that they're making. And they're also, there's talk about maybe we won't have a step up in basis. I've got clients, after a Biden win, I've got clients who are triggering gains this year to offset them with the unlimited charitable deductions. So you can do some income tax planning and charitable planning this year that you might not be able to do another year. I just want to mention that.
And to expand on that a little bit, it is very important to do planning related to that. That 100% AGI limitation, which means no limitation at all, applies to cash gifts to public charities. And so you have to be very careful on who you're planning on giving to, and also think about whether you have charitable contribution carryovers, because those may not be used because there's a stacking rule that applies in which order deductions occur first. And so you might think, oh, well, I've got these other charitable deductions that are carrying forward from a limitation from the year before, and they'll be able to be used in that 100% AGI limitation, but in fact, they will still have the old AGI limitations in play. And the first one that comes into play is cash. So if you've already exceeded those 30% AGI limitations or things like that, you will not get those additional deductions this year. So there's a lot of planning that needs to be thought about. And Marie gave a great example of taking appreciated stock and selling it, recognizing the gain because you're going to get the full deduction versus just contributing the appreciated stock in 2020.
Okay. So what other advice do you provide when you're talking to folks about using or including charity in their estate planning? Either Marie or Doug.
Well, I'd say I first want to know what the client's intentions are, what the place of charity is in the plan with respect to family, and make sure that we maintain that proportionality. I mean, is it something where they want charity to get a portion of the entire estate? We want to make sure that if asset values change over time, that it doesn't become a disproportionate share. So I think that we have to be very careful with that. And then it's also with picking the structures and the assets that we use, like retirement accounts, as Doug said, are great. We have lots of tools available to us, including some charitable tools that allow the donor to obtain income over the donor's lifetime, like a charitable remainder trust or a charitable gift annuity, so that the charity will benefit either at the end of a term of years or at the end of the donor's life. We have, just lots of good tools that we just have to carefully walk through with the client to understand their objectives and find the best solution.
Okay.
And I would encourage that this is absolutely a time to involve the financial advisors in the process as well, because one of the most important pieces of the process is asset selection
Right.
in the overall plan. And so getting the input from the financial advisor is also very important.
Are you seeing particular types of charitable gifts that people favor over others, or what types are you seeing?
I've seen an increase in the charitable remainder trusts, although I haven't seen a lot of charitable lead trusts, which is where the charity gets the assets on an annual basis and the remainderment goes to the beneficiary. It's the opposite in a charitable remainder trust. But that one seems to be getting more interest with a lot of my clients because they can see the benefit going to the charitable organization now when they may need it versus later on when they wouldn't be able to enjoy them benefiting from it.
We do have a question about whether someone should do a donor advised fund or a foundation, a private foundation, and what to think about that. So, and also another question about whether a donor advised fund is a public charity, which I can answer that, it is. But does one of you want to kind of compare briefly what people should think about?
Yeah, can I do that one?
Thank you, Marie.
Yeah, because just thinking about that. And I think Doug will agree with me on this. When clients are thinking about a private foundation, unless they have a very particular purpose that they want to serve, and it's going to very often, if you're thinking that this is going to last for at least another generation or something, that's a function that people will think that they would like a foundation for. But I still encourage them to take this concept for a test drive with a donor advised fund first, because you can replicate a lot of the things that somebody might want to achieve. You can sit around the table at the holidays with your children and have them propose charities to receive gifts and so on, without all the startup costs, the maintenance and so on that you have with a foundation. I've had clients start foundations and decide they didn't like them, and then we had to unwind them. If they'd only done the test drive, they might have understood that there were these issues. There's also serious compliance issues that you have to be mindful of with a foundation. If there are investments you can't make, there are transactions you can't engage into with the foundation, you step into it and you've got a serious problem. So if you structure a foundation, you're going to want serious professional help with compliance as well.
So I want to get into the question and answers, and folks have some questions about being trustee in general. So Marie, is it a bad idea to list your trust and estate attorney as personal representative or trustee of a trust?
It's not necessarily a bad idea, but in my experience, unless the law firm has a specific division, that's really a trust department, I mean, a trust bank, many attorneys will say that their best used, their highest and best use is as counsel to the trustee, because we're generally not set up for the investing part of it, the dealing with the family. I mean, there are exceptions, but as a general rule, it certainly isn't something that I would advocate for. It's more customary on the East Coast. There are actually some old line law firms they've formed trust banks basically, and it's a real business, and they have all the compliance down and so on, and the safeguards that you need and want.
Right. And they basically charge pretty much the same as corporate trustees, right? And that's one of the questions, is what corporate trustees charge. And I think I can probably say, from having worked for a corporate trustee, that you probably have to look at the individual corporate trustee. They certainly charge for their services, and it's often on a percentage basis. I will compare that with an individual trustee is allowed also to charge, although probably it has to be by hourly. Is that correct?
Yeah, usually that's what we do generally. Okay. In Michigan, there's not a statutory percentage.
Right. So it's kind of hard to compare apples to apples on what the charges are going to be that an individual might charge versus a corporate. But, folks should certainly, as Doug suggested, get to know the bank or whomever they're thinking of for corporate trustee, if that's the route they want to go, and see what the charges are going to be. Do you recommend friend and corporate trustee when family is not appropriate or available? So that sounds like a co-trustee situation, maybe friend and corporate.
That can work. That can work well. What you want to consider is when they're co-trustees, just as garden variety co-trustees, they're equally responsible for the actions of one another, and it can be, you subject the individual to the same potential liabilities as the corporate trustee. There are other structures that you can use. You can have advisors to the trustee. Now in many states, you can have what's called a divided trusteeship, where you have special purposes trustees. So the individual could be the trustee who makes decisions about the distributions that are made to your kids, and the corporate trustee has full responsibility and sole responsibility for administrative matters, investing, tax compliance, and that sort of thing. But the desire to bring an individual or a friend together with the corporate trustee, there are lots of ways of doing it, and it can make a great partnership, and a lot of good corporate trustees will welcome that, because they'll want the insight of someone who knows your family and what your objectives were. Just explore the different alternatives for accomplishing your goals.
And I would add to that and say that the individual friend or family member that's named as an individual trustee might welcome the opportunity to partner with somebody from a corporate side to, yes. If they're not used to filling in that role, they then have somebody who can help with some of those additional roles and responsibilities that might be required.
Okay. If a person is a Michigan resident with a will drawn in Michigan, and that person becomes the resident of another state, does the will have to be redrafted in the other state?
Well, as a general matter, no. Wills are generally, respected one state to another if it was validly executed. If you're married, however, you want to be alert to the fact that we have two systems of property ownership in this country for married couples. And it's 9 or 10 states that are community property states, and the drafting of your will and trust is really predicated on the property system of the state where you live in. And if you've got community property, if you're in a community, you move to a community property state and you're married, you're going to want to have that revisited. If you go to another separate property state, it's not an issue. If you're single, it shouldn't be an issue. Your powers of attorney should be updated to local law. They're very local law dependent. And finally, you still want to have everything reviewed because, particularly if you have significant assets, because some states still have state, estate, and inheritance taxes. And there's planning that can be done around those that, you know, your Michigan documents wouldn't take into account.
Okay, a couple tax questions, Doug. Can I give a qualified distribution from my IRA to charity at age 65 before I am required to take my required minimum distribution?
Unfortunately, no. You have to be of age to be mandated for a required minimum distribution to be able to make the QCD. It doesn't have to only be the required minimum distribution. It can be any amount or a portion thereof, but you do have to be of age where you're required to make the distribution.
Okay. Does it make sense to offset 100% of AGI against income that would be taxed at 10% and 12%?
To an extent, that's a personal decision.
Okay.
Obviously, you know, no taxes in some people's minds are better than a small amount of tax. But is there a way to structure it so that you could take the rates that could be at 28 or 37% over 2 years and get the deduction that way and maximize that? That is also a possibility. But
Okay.
it just depends on each individual.
And someone is asking about eliminating the stepped up basis. What would the effects be about eliminating the stepped up basis?
Well, again,
I could just say it would be nightmare, but
it's crystal ball, you know, if I had the crystal ball, but I think Marie and Donna just summarized it very well. It could be very nightmarish, problematic. It would be very.
I mean, to go back and figure out bases from stocks that people have held for 50 years. I remember when this was, you know, from the 80s when this was talked about. Oops, just dated myself there. But anyway, yeah.
Yeah, and I mean, we do a lot of planning on, oh, well, let's keep that asset because we don't really know what it is and we're going to get a step up in basis. And then the other side of it is how will that interplay, you know, if the preferred capital gains rate goes away and then you don't have a stepped up in basis, now we're talking significant income tax ramifications, especially if those assets are held within the trust, because you get to the highest tax bracket within a trust for income tax purposes at just over about $14,000 in a given year. So it's a much lower tiered structure. And so chaos could come into play.
Okay, so hopefully this won't get you into the weeds, Doug, but could you please comment on the tax implications on generation skipping inheritance? In particular, what are the grandchildren's tax obligations when they inherit their parents' estates? And that probably gets into the weeds a little bit, right? Because there's the different types of. Yeah,
and I'm not quite sure on the full piece of that when they say the grandchildren for the parents, because the generation skipping tax really comes into play with the grandparents to the grandchildren. So you right. Literally are skipping that second generation. Yeah. But what exists is a corresponding exemption that allows you to pass assets along to the third generation or the skipped generation without any income tax. Otherwise, you have to pay a tax for the level that has been skipped, simplifying it very, very, very much.
So Doug, I think you said there's no income tax. You meant estate or generation.
I meant estate or generation.
Yeah. But there is a significant exemption. So before it's an issue, right now, this year, the maximum GST exemption is $11,580,000. So you'd have to go beyond that before you'd have any issue. And then it does depend, Donna alluded to this, there are 3 types of generation skipping transfers, and some, the taxes paid from the property, some the recipient pays it, some the donor pays it. But you're at a level, and we try to avoid that happening. Good planning avoids having that happen.
Right, right. So just going back to a couple things, Doug, someone says, I thought the required minimum distribution age was lifted to 72 years.
It is, yes. With the
All right.
Secure Act, it went to 72 years.
But the qualified charitable distribution, it stays at 70 and a half, right?
Correct.
Yes, okay. And then a couple of charitable type questions. I'll take this one. Can U of M act as trustee of certain charitable remainder trusts? Yes. And Sally Baker and her team would be happy to talk to you about the different types of those. Are pour over will provisions needed, Marie?
Well, yeah, if you have a trust, if you have a revocable trust, the purpose of a pour over will is to say, if I missed getting something in my trust, the trust becomes the central clearinghouse. It directs the disposition of all of your assets that would move by trust or by will. And so you want to move them out of the estate into the trust. So you want pour over for that purpose. There are some circumstances, though, where you would have a will that pours over certain assets and not others. If you have real estate in another country, you have a cottage in Canada. I mean, there are a lot of places that don't recognize trusts. And so you don't always pour over everything. But if garden variety situation, you would just use the pour over clause.
Good. Thank you both very, very much. This has been very enlightening, I think, and I appreciate Marie and Doug your time today. And now I'm going to hand it back to Sally Baker.
Thank you, Donna. I think we had a few questions that didn't get answered. For additional information, especially regarding charitable gifts, please visit our website at plangiving.umich.edu. We'll also have a follow-up email that will have our contact information for myself and my colleagues in the Office of Planned Giving. I want to give a big thank you to our panelists for sharing their expertise today. Thank you so much. And we're really pleased that about 150 people were able to join us on this call today. So thank you, and go Blue.